Commissioner, I call Sarah Vandenbroek.
Yes. Will you take an oath or make an affirmation?
Make an affirmation, please.
Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say I do.
I do.
Ms Vandenbroek, what's your full name, please?
Sarah Vandenbroek.
You have prepared two statements and provided them to the Commission. The first is dated 9 June 2026. Are the contents of that statement true and correct?
Yes, I do.
Commissioner, it bears the ID sta.0326.0001.0001, and I tender that statement.
Yes. That statement will be marked as an exhibit.
Ms Vandenbroek, you've also prepared a more recent statement dated 26 June 2026, which has been prepared in a redacted form. Are the contents of that statement true and correct?
Yes.
Commissioner, I tender the redacted version of the statement for present purposes DTR.899.0002.0001.
Yes. The redacted second statement will also be received as an exhibit.
Ms Vandenbroek, you're a First Assistant Secretary in the Department of Infrastructure, Transport, Regional Development, Communications, Sport and the Arts.
Yes.
That's a division, or within the department, you're responsible for a online safety and classification division, is that right? And that's the division of the department responsible for the regulation of digital platforms and for online safety.
Yes.
You commenced work in that division in September 2024.
Yes, I did.
Now, as First Assistant Secretary with responsibility for digital platforms, do you have a general understanding of the business model of social media platforms that operate in Australia?
Yes, I do.
How do social media companies generate revenue from providing content and services to Australian users?
I understand the majority of revenue is generated through advertising. Some have subscriptions and other arrangements in place depending on the nature of the service. Some of the platforms have, particularly the gaming platforms, have in-game purchases, but for the main social media platforms it is largely advertising revenue.
Attracting new users and increasing the use of the platforms by existing users is central to the model of those main social media platforms. Is that your understanding?
Yes, it is attracting and retaining users and maximising the time that users engage with the platform.
Yes, and the display of advertisements to individuals in Australia engaging with or interacting with the social media platform generates revenue. So those interactions might include viewing or sharing or commenting on content. Is that right?
That's correct.
Is it your understanding that as a general proposition, the more eyes a social media platform has on the service that it provides, the more revenue it can stand to make from advertisers who wish to advertise to Australian users?
That's my understanding.
Do you understand that to create a financial incentive to have content on the service that is either interesting or controversial, because in either case interactions with that content will increase?
That is my understanding, yes.
And do you understand that to include a financial incentive for social media platforms to promote or acquiesce in the spread of harmful content online, because it is likely to be, or more likely to be, controversial or shared or commented on?
That's my understanding, yes.
Is that a key challenge that must be managed by the government in designing effective laws to regulate social media platforms?
Yes, it is certainly something the government is interested in looking at.
Now, you've given evidence in your first statement about the Ricard review.
Yes.
And the Online Safety Act contained a provision that required an independent review to be undertaken of the operation of the statute within 3 years of its commencement.
Yes.
Ms Ricard was appointed to undertake the independent review.
She was.
And Ms Ricard is herself a very experienced regulator.
Yes.
She was the deputy chair of the ACCC.
Correct.
Prior to that, she held senior roles within ASIC,
Yes,
and she was awarded the Public Service Medal herself in 2011.
she was.
The Rickard Review was announced by the government on the 22nd of November 2023,
Yes,
and the review ran for nearly a year,
yes,
and she was supported by a secretariat within your department,
that's correct.
and an issues paper was published in April 2024.
Yes,
Stakeholders were given an opportunity to make submissions about that issues paper.
they were.
There was extensive stakeholder engagement during the review process,
Yes,
and that involved engagement from social media platforms.
it did, yes.
Can I bring up Ms. Rickard's final report? It's EWR.599.0001.0039. And if we could go to PDF page 27, please. In the bottom half of the page, there's an overview of the review process is set out. And you see Ms. Rickard received 2,200 responses, the top of the right-hand column.
Yes,
There was an extensive process of consultation that's set out in the bullet points in the right-hand column, including 72 meetings that she held with stakeholders,
yes,
and she held 7 roundtables.
correct.
Now, could we go to PDF page 198, please, in the Appendix C of the document. It's an appendix that sets out a list of the individuals and organisations who were consulted, and they include all of the major platforms.
Yes,
And then if we go to the next page, page 199, a series of roundtables were held, and a roundtable was included roundtables with community groups that were regarded as disproportionately impacted by online harms.
yes,
And the Executive Council of Australian Jewry, among others, was consulted.
yes, Now,
Ms. Rickard was required to report by the 31st of October 2024, with which she complied.
yes,
We've got almost to page 200 in the document on the screen. It was a long and detailed consideration of the issues,
yes, it was.
and it provided a series of recommendations to the government for review or amendment of the Online Safety Act.
Yes,
And they included recommendations in 3 particular areas: a digital duty of care, introduction of a definition of online hate, and changes to the adult cyber abuse scheme.
yes,
Now, just pardon me for a moment. The government has, the Commonwealth Government has published a response to the Rickard Review,
yes,
and that response was published on the 14th of April this year, 2026.
yes, that's right.
Can you explain, please, to the Commissioner the circumstances that led to it being 18 months between the provision of the report to the government and the delivery of a government response?
Certainly there was a lot of detail to work through. As you would know, there were 67 recommendations in the report. They are very detailed, very wide-ranging. We had to work through them in tranches to understand what the practical implications would be of implementing them, and indeed whether it made sense to implement all of them where some may overlap. We worked with other government agencies and with the E-Safety Commissioner's team and with our Minister's Office to form positions on those recommendations. We also had to take into account other work that was underway, including a reform of the classification scheme that was in progress at the time. And we had to look at how we could sensibly sequence the work. It wouldn't have been feasible to try to implement all 67 recommendations at once. The government had already announced an intention to focus on the digital duty of care, so we were progressing that work as well. We were also very much focused on the social media minimum age work, so it did take time to work through the plan with regard to all of the recommendations.
Ms Vandenbroek, could I just ask you to speak up a little?
Sorry.
No, the transcriber's just having a little difficulty with your soft voice.
Sorry, I will try to speak louder.
Thank you. You referred to the work the department was doing at the same time on the social media minimum age
Yes.
reforms. Those changes came into effect on the 10th of December 2025, as I understand it.
That's correct.
But the legislation for that purpose was passed on the 27th of November 2024.
Yes, that's correct.
So there was the work required to be done by departmental officers was in the context of not of developing the legislation for social media minimum age, because that had already been put in place in November 2024.
That is correct. We were focused on the media campaign and the awareness raising, working with the E-Safety Commissioner on the regulatory guidance and just generally raising awareness.
How many officers within your branch were involved in the task of considering and preparing the response to the Rickard Review?
There is a core team of 8 or 9 staff. It has changed over time, generally depending on whether we have a graduate in the team or not. They were the same team that were responsible for the early work on the digital duty of care.
And they were the same team that were, as you've explained it, at the same time as considering the response to the Rickard Review, they were otherwise progressing consideration of the digital duty of care. Is that what happened?
Yes, the same team worked on the Rickard Review and the duty of care.
You accept that it's the E-Safety Commissioner who's responsible for administering the legislation as it applies to the social media minimum age?
Yes, that's correct.
So departmental officers weren't engaged in that aspect of those provisions?
No, we weren't.
Yeah. Do you consider that the branch that you lead was not adequately resourced to manage platform policy in a timely way because it took that 18-month period to develop a governmental response to the Rickard Review?
No, I think it was more the complexity, and there was also an election during that period, which meant a change of minister for our portfolio. So we had a caretaker period where we couldn't work with the Minister's Office, and then we had a new minister. There was a process of briefing the new minister and the new office on the review. So a lot of the work that was done when the report was first handed over was then redone with the new office to make them familiar with the recommendations and the content, which is quite extensive. So that contributed to the delay, and then it was the availability of various stakeholders and legal advice We have a fabulous legal team in the department, but we put a lot of pressure on them from a lot of different angles. So we couldn't ask for everything to be done all at once.
Could I bring up the text of the response, please? Which has the ID RCD.0001.001.0193. So this is the government response, which I think ran to some 16 pages.
Yes, that's right.
Yeah. And if we go to PDF page 3, in this context, there's a an indication of the government short form response to each of the recommendations, which support in principle, note, or not supported.
Yes.
Now, the support in principle category says it's used where the government supports the intent or merit of the recommendation, but considers that there are other more effective ways to deliver on this intent, or where further consideration is required to consider implementation, resourcing and prioritisation options. So support in principle might include circumstances in which the recommendation gets taken no further.
It does. The support in principle indicates that we may or may not. It's not closing the door on any of the recommendations. It means we need to do further work to determine whether it will be taken forward or not.
Or if there are other options for implementation, resourcing or prioritisation, perhaps doing nothing is incorporated within the support in principle category.
It can be, yes.
The note category refers to further analysis being required.
That's correct.
Not supported is clear. In respect of the note category, which suggests further analysis is required, or support in principle, which refers to further consideration, has any further consideration or analysis occurred?
For some of the recommendations, yes. For others, we haven't got to them yet.
In respect of those that have been further considered, is there any development or update on the government response to the recommendations?
We haven't
inform the Commissioner of?
We haven't produced a formal update to the government's response. It's more that we're working internally and with the Minister's office on ways to address those recommendations.
How many recommendations are the subject of further analysis and consideration?
I don't know the number to hand. I would need to look through them to work that out. I could work that out for you. It would take me a couple of minutes.
Yes, thank you.
There are 18 of the support in principle recommendations where we have done further work since the government response was produced.
18 of the recommendations?
Of the ones that are marked as support in principle.
Yeah. I see.
Of those that are noted,
So I think 20 of the recommendations had the response support in principle, and your evidence is 18 of those 20 have been the subject of further analysis or further consideration.
yes.
But the final position in terms of the government's response to those 18 recommendations has not yet been determined. Is that right?
Some has. I could work through them all individually if you would like.
In terms of numbers, how many of them have been resolved? In other words, a government response finalised.
There are a number that relate to reach and risk, and as I think I've said in my statement, there was a position on those. It wasn't that we were doing more work, we already had a position which was that they would be adopted to the extent that it's about risk but not about reach. So they were supported in principle in that they would be enacted but not exactly as the recommendation was written, because they are quite detailed recommendations. Some it was decided that they would be progressed but in a slightly different form to what was recommended.
Do you have an estimate of when a complete government response to the Ricard review will have been prepared or finished?
No, I don't, sorry.
And what's the explanation for the additional time since April that's been required when government already had about 18 months to respond to the review?
We did a further round of consultation in relation to the digital duty of care through May and June, which helped to inform some of those positions. We've also been progressing legal advice on some of the positions, and the consultation particularly involved talking to the platforms about how different things would work in practice and working in detail with the Safety Commissioner's team on how they would work from a regulatory perspective.
Right, ask you some questions about the digital duty of care, which of course is a recommendation in the Ricard review, but also I think independently and before the Ricard review was a proposal that the Commonwealth Government had indicated it would pursue.
Yes.
There have been a series of ministerial statements of support for the implementation of a digital duty of care.
They have, yes.
And both in the last administration and in the current government.
Yes.
How long has the branch you supervise been considering or developing the digital duty of care?
Since it was first announced in late 2024.
Now, can I take you to an email, please, which has the identifier esc.0.110.0001.1903. You can see that on your screen.
I can, yes.
It's an email from the E-Safety Commissioner to a series of departmental officers in January this year.
None of those officers are in my department. They are all staff of the Safety Commissioner.
Oh, I see. Including the copied recipients?
None of those people are in my team.
I see.
They are all e-safety employees.
So, and you haven't seen the email before otherwise?
No, I haven't.
It refers to a meeting with the department, you see in the first paragraph of the email.
Yes.
And there's a reference to Mr. Cole, who's acting in the position that you hold now.
That's correct.
And the meeting included, as one of its attendees, the Special Envoy to combat anti-Semitism.
Yes.
And you see in the next paragraph, about halfway through, at the meeting in January, this e-safety commissioner email reports on the Special Envoy being clearly frustrated when told that the digital duty of care course of action could take up to 2 years for full consultation and implementation.
Yes.
And is that a matter that you otherwise have an understanding of, namely that the Special Envoy has been pressing for a more prompt implementation of a digital duty of care because of its particular effect on Jewish community?
Yes, I am aware of that.
And is it right that, as reported in this email, which of course is not a departmental email, but the expectation in February this year, or January this year, was that the duty of care was expected to be implemented in about 2 years?
The expectation was that the legislation would, the indicative timetable is for it to be introduced by the end of this year, but there will be a 12-month delay to the commencement of the duty of care, so that accounts for the second year.
Do you accept that is a very long time frame in circumstances in which the Ricard review commenced in 2023 and reported in 2024?
It is a long time, yes.
Does the department accept that there is an urgent need for a better regulated online environment for the protection of the Jewish community specifically and the community more broadly?
Yes, we do accept that.
You can understand the clear frustration of the Special Envoy in the circumstances?
Yes, I can.
Can I take you to paragraph 74 of his first statement? Is this still the 74 to 77? Does that still set out the presently envisaged timetable for the implementation of the digital duty of care reforms?
That is the timetable that we are working to, yes.
Do you consider that to be realistic, optimistic, pessimistic?
I think that the timetable for drafting of the bill may be optimistic. I can't comment on the introduction. That's subject to parliamentary process. That's a matter for the government that I don't have any involvement in. In terms of the 12-month delay to take effect, that's something that we did for the social media minimum age in consultation with the platforms because it is because it was a new concept that hadn't been done before, so we accepted that it was a significant change for the platforms to put in place. At this point, we have been planning on a 12-month delayed effect of the digital duty of care. It's possible that the government may decide to shorten that time frame. That would be a decision that we would need to seek the government's view on. It's not something that within the department's control.
Yes, I was going to ask about that, because the circumstances are quite different for the digital duty of care as compared to the social media age provisions, aren't they?
It is, yes.
Yeah. Including because the social media platforms have been well aware, at least since the end of 2024, that government made a formal commitment to proceed to implement a digital duty of care.
That is correct, yes.
And they all engaged with the Ricard review over the year-long consultation process that she undertook for her statutory review.
That's correct.
Do you consider there is a strong case for a very marked reduction in any delayed commencement period?
I think that's correct. I think when we started this process, there wasn't the focus on the duty of care publicly and within particular groups as what there is now. So there is probably now a case to go and ask the government for whether that time frame could be realistically shortened. I don't imagine that would be well received by the platforms, but as you say, they have been aware for a very long time that this is coming.
Indeed they have. Can I take you then to part of the consultation with the social media platforms, and this is at the end of last year, the end of 2025. I'll call up a document which is DTR.0326.0001.0676. No, that. Sorry, I gave the wrong ID. It's DTR.0326.0001.0364. Yes, thank you.
Thank you.
Have you seen this document before, Ms. Vandenbroek?
I have, yes.
Yes. So it's a summary of digital duty of care consultation,
Yes.
and it takes the form of referring to various industry roundtables and meetings in that on that topic, including a reference to the attendees in each case.
Yes.
And on the front page is a 27 November meeting with a number of identified carriage service providers and social media platform providers,
Yes.
and a second meeting on the 27th of November, also described as a roundtable with some other social media and tech company
Yes.
attendees.
Yep.
And in the second roundtable, the first bullet point refers to a majority of stakeholders agreeing that a more formal consultation process and more detailed proposals would be appropriate so they can make formal submissions to be considered by government.
Yes.
Is it fair to say that the general approach over the platforms over the last few years, to your observation, including at the end of 2025, has been to ask for further rounds of consultation and consideration before government proposes the implementation of a digital duty of care?
Yes.
And so far as you're aware, have all the major platforms taken that approach, namely to call for further rounds of consultation and consideration?
Yes, we re-met with all of the major platforms in May and June as part of the further consultation.
In May and June this year?
Yes.
And have they called for yet further consultation and
They
consideration?
have asked to see a draft bill when it's available.
And the opportunity to make submissions and
To
be
comment on
consulted
that.
about that?
Yes.
Can I ask you a particular question about X Corp, and I'd call up a separate document, which is DTR.0326.0001.0672. So you're familiar with this form of document? A digital
Yes.
duty of care consultation survey?
Yes.
Yeah. Could you explain what the survey is?
It was a survey that was put out publicly to capture views about the digital duty of care. It was launched on our website. It was available for anybody to respond to.
Yes. And one of the it was a survey at the end of last year, the end of 2025.
That's correct.
And if we go to the final page of this document, please. You see the top of that page. This is a survey response that X Corp completed and submitted.
Yes.
And you understood before today that X Corp completed a survey response,
Yes.
and this document doesn't seem to be, it's not itself signed, but it indicates that it's sent by email by an identified officer of X Corp.
Yes.
And if we could go back to the first page, the format of the survey was to ask questions and then to call for a response from whoever was supplying it. The first question was, which of the following kinds of harmful experiences or content do you think digital platforms should take steps to prevent for young Australians under 18 years? And then there's a series of harmful forms of online content.
Yes.
And X Corp ticked the box, none of the above.
Yes.
And then if you go over the page to question 3, for example, which of the following kinds of harmful experiences or content do you think digital platforms should take steps to prevent for Australian adults on their platforms? And then there's again a series of boxes that are available to be checked for various types of online hate speech and violent pornography and content that seriously withdraw that content that promotes seriously harmful behaviour.
Yes.
And again, X Corp ticked none of the above.
Correct.
Do you regard these responses as credible policy positions for a mainstream social media platform to take?
No, I consider that's disappointing.
Are you aware of other platforms taking this approach?
No, I'm not.
Have any other platforms gone to the length of filling out a survey response and submitting it in the context of this survey?
I don't know the answer to that.
Then can we go to a separate document, please, operator, which is DTR.0326.0001.0676, which is a letter from X Corp to the department dated 5 December 2025.
Yes.
Now, that's a single page letter and signed off kind regards X Corp.
Yes.
It doesn't identify, well, it's not signed by an identified officer.
No.
Is that conventional from stakeholder corporations, or is it peculiar to X Corp in your experience?
In my experience, it's peculiar to X Corp. The major platforms would normally have a named signatory.
Now, on page, it attaches a written submission, doesn't it?
Yes, it does.
And can we go to page 0677? And you'll see in the introduction, the third paragraph. Have you seen this letter before, by the way?
No, I haven't,
Yeah.
sorry.
So tell me if you need to review the letter more generally, but if you look at the introduction and the third paragraph of the introduction, just read that to yourself.
Yes.
And is this another example of requests for further rounds of consultation by social media platforms?
It is, yes.
And do you consider the practical effect of these types of requests to be the delay in the implementation of a reform that 2 Commonwealth ministers have unambiguously said will occur?
Yes.
Now, you've referred in your statement to those documents can be taken down, thank you. You have given evidence in your statement that there was to be a workshop between the department and the E-Safety Commissioner's office in June this year.
Yes.
And I think you've referred a little earlier in your evidence to further work being done by the department in May and June.
Yes.
Did that workshop with the E-Safety Commission occur?
Yes, it did.
And then there are further stakeholder meetings that you've referred to in your first statement as being planned, have they all occurred, or are they still in the process of being organised? And
They have all now occurred.
they've all now occurred?
Yes.
Now, so from the department's perspective, are there further stakeholders, to use that term in its broadest sense, that the department proposes to continue to consult with in relation specifically to digital duty of care, or is consultation now complete?
It is completed to the extent we have anything planned. If we are approached by anybody else who wants to meet with us, we will take those meetings. Equally, we sometimes have somebody recommend a stakeholder to us and we would reach out to them, but at this stage there's no further planned meetings.
And this is in the context where on the current timetable the draft bill will be prepared next month.
Yes.
And is that well in train, or is it yet to commence? What stage is that at?
We understand that a drafter has been allocated. I'm not aware of any work on the drafting having started. We have had an initial meeting with the Office of Parliamentary Counsel to talk about the policy intent of the bill, and we have provided some drafting instructions.
Is it your assessment that a key reason why the main recommendation of the Rickard review have been delayed and are not yet implemented is that there has been a concerted effort by technology and social media companies to stall the implementation of the recommendations?
No, I don't think that has had a significant impact on the timing.
It is your assessment, is this right, that there have been extensive efforts by social media platforms to require further rounds of consultation and consideration and submissions, which have the practical effect of delaying implementation?
That is correct. They have characterised their requirement for extra meetings as wanting to understand the detail so that they can provide input to us on how it will work in practice. The multiple rounds of consultation does, of course, slow the process down. But also it's quite usual when we work with them that they want to be across the detail and that it is an iterative process.
Yes, but again, this is in the context of a reform that the relevant Commonwealth Minister first said in November 2024 will occur, and that when government changed, the current Minister promptly said will occur.
Yes.
Could I ask you about some of the particular recommendations in the Rickard review in terms of the government response? In your statement, just to go back a step, you have referred to analysis that was conducted both of the EU and UK models for regulation of online content.
Yes.
And each of those jurisdictions has a digital duty of care, but they differ in their form.
Yes, that's correct.
And you referred to your assessment that Australian industry favours a UK model, or an analogy to the UK model being adopted?
Yes, the social media companies prefer the UK model. Other stakeholders stated a preference for the EU model.
Yes. Now, you have referred in one particular aspect of this is the industry preference, by which you were, I think, referring to
The social media platforms.
The social media platforms.
Yes.
For a safe harbour provision.
Yes.
Could you explain what you understand that to mean?
The safe harbour provision? Yes, certainly. The UK model is a very prescriptive model. It involves thousands of pages of very detailed and specific regulatory guidance, which sets out the minimum compliance requirements for each type of service. So it sets out in a very detailed way the minimum compliance requirements, which means the platforms can do exactly that and no more and be confident that they have complied with the regulation. By contrast, the EU model, or a more principles-based model, requires that the platforms risk assess their own services and the features of those services, and that they put in place appropriate mitigations for the risks, and that they then evidence to the regulator that they have put in place appropriate risk mitigations without the regulator prescribing what that would look like.
And how does that operate as a safe harbour?
So in the detailed model, it's a safe harbour because there's a minimum compliance level, so the platforms know that if they do precisely that, then they are safe from any regulatory effort from the regulator or any enforcement.
Thank you. And now, can I ask you first about the recommendation number 6 in relation to risk management and data sharing? You're aware that the EU's Digital Services Act contains a requirement to this effect in Article 34?
Yes.
And this is a recommendation that's supported in principle by the government?
It is, yes.
And you've given some evidence in paragraph 67 of your statement that the duty of care will require certain matters in relation to identification of risk of harm by an assessment.
Yes.
So does that involve more than support in principle? That involves support of the recommendation, does it not?
It's supported except to the extent that the recommendation references reach and risk.
I see, yeah. And as you explained earlier, or perhaps if you could explain the difference and why government's looking to risk and not reach.
We believe that there are a number of platforms that are small that have low reach, so not a large number of users, that can still be very risky, particularly new platforms when they first become available in the market. They may have a very low number of users, but they may be high risk. Equally, there are platforms or there are services like the online streaming services, so things like Netflix, that would have a very high reach, but all of their content is moderated and all of their content is classified, so they would be considered to be relatively low risk.
Yes, thank you. Recommendations 9 and 10 deal with the provision of transparency reports that address particular topics, don't they?
Yes.
And there's a general equivalence to Article 37 of the European Digital Services Act.
I'm not aware of the exact article, but I'm aware that those concepts
Yes.
are in that piece of legislation.
Now, is it right that the government does support the generation of transparency reports, but again it's a question of it applying to a risk-based assessment rather than a reach-based assessment of the social media platforms?
Yes, so with recommendation, was it 9 and 10, sorry, that you
9 and
referenced?
10.
Yeah, so with 10, again, yes, we agree to that recommendation, or the government, agrees to that recommendation, but in relation to risk and not reach. And with recommendation 9, that is supported, except that the power will be given to the minister, or the minister will ask the commissioner rather than the power going directly to the commissioner.
So, now, in relation to recommendation 11, this is another recommendation supported in principle,
Yes.
but does not appear to be too controversial, because what it requires is that there be a well-resourced compliance function that reports directly to senior management. So what aspect of that is still being considered?
Whether that is something that we would be able to effectively regulate and enforce.
And does that question arise because of the overseas domicile of many of these social media companies?
Yes, it does.
You referred a little earlier to the department having taken advice on some of the issues that arise in respect of the implementation of the Ricard Review recommendations.
Yes.
Is that general topic of the effect of the overseas domicile of most of these social media companies, has that been the subject of formal advice to government?
I don't think that we have, no, I don't think that we have sought formal legal advice on that.
So the advisors on international law, to your knowledge, have not been engaged either with government or from external providers on that topic of the effect of the overseas domicile of social media companies on the implementation of reforms?
I don't recall exactly the details of what we've done in that space. I know that we have had conversations with the Attorney General's Department about the concept through an interdepartmental committee chaired by a Deputy Secretary in our department. I know that it was discussed there and there was a paper prepared. That was a policy paper though rather than legal advice. I'm sorry, I don't recall specifically legal advice on that.
You agree it's an issue that is absolutely central to the question of implementation of the Ricard Review recommendations, or at least some of them?
It is, yes.
You've referred at the end of your first statement to the Australian-United States Free Trade Agreement. Can you go to paragraph 158?
Yes.
You were asked a question by the Commission, and your statement provides an answer to it in respect of recommendation 43 in the Ricard Review. And just to remind you, that recommendation was that the government should consider the feasibility of requiring major platforms to have a local presence for the purpose of facilitating enforcement action.
Yes.
And you appreciate that involves the same general topic of advice, namely the effect of overseas domicile of most of these social media platforms on Australian regulators.
Yes.
And indeed on Australian legislation and its applicability.
Yes.
You say in paragraph 158, to the extent you're in a position to comment, you understand the Australia-US Free Trade Agreement, an article of it impacts whether this recommendation can be implemented.
Yes.
Do you know whether government has sought or obtained advice on the topic of whether the Australia-US Free Trade Agreement would prevent or require some particular structure in order effectively to regulate social media companies that have an overseas domicile?
I'm not aware of having sought formal legal advice on that, no.
How is it that the government could be considering its response to the Ricard Review without an understanding of the legal position?
For that particular recommendation, we were aware that the government didn't intend to progress that recommendation, so we didn't require legal advice. The position was that that one wouldn't be progressed.
So far as you're aware, the rejection by the government of recommendation 43 was not done on the basis of having received legal advice on the operation of the free trade agreement with the US. Is that the position?
No, I don't know whether the minister or the government sought legal advice on that. I can only answer for my team, and we didn't seek legal advice on that one.
Yes, no, I understand. So for the purpose of the work that your branch has been doing in preparing the government's response to the Ricard review or assisting the minister in preparing the response.
Yes.
You yourself, as the head of the relevant branch, are not aware of any legal advice on the topic of the legal effect of the overseas domicile of social media companies on the implementation of these suggested reforms?
No.
In respect of recommendation 17, Ms Ricard recommended that the government should develop a whole of government no wrong door approach to support individuals seeking help to address online harms,
Yes.
and that was supported in principle in the government response.
Yes.
Has further work been done on that subject matter?
It has been, yes.
And you no doubt have become aware, or I withdraw that, is it the case you've become aware of witnesses giving evidence in this commission who have expressed frustration about not being able to find the right part of government to deal with issues of online hate and its consequences for them, in particular members of the Jewish community?
I am broadly aware, yes.
Yeah. Now, what you've said in your statement at paragraph 111, the recommendation is supported in principle, but it presents what you describe as real challenges in enabling this type of broad-reaching cross-agency cohesion. What are you referring to in that regard?
In terms of setting up a pathway where if any government agency was approached about online harms or online issues, putting in place pathways for that information to be captured by any agency and passed to the Safety Commissioner would be challenging. There would be a lot of resourcing required to make sure that the information, which is likely to be very personal and very sensitive, was handled appropriately and was protected appropriately. Having it pass through multiple people in multiple agencies does increase the risk of inappropriate safeguarding of privacy. Obviously that can be overcome with appropriate procedures and systems, but there would be a considerable amount of work required to put that in place. The E-Safety Commissioner is very opposed to that idea and has asked us not to, her team has asked us not to pursue the no wrong door approach. Our preference instead, where we think we get more value for the investment of time and money, is in raising awareness of the E-Safety Commissioner.
You've also referred to this topic in your second statement, paragraphs 14 to 16, and you refer to two options involving what you've described as journey maps on the one hand or warm handovers on the other. Could you just briefly describe what each of those options involves?
Yeah, there was a policy paper developed by my team looking at those two options. The warm handover is the idea that rather than one officer of one department telling the complainant to go to the Safety Commissioner, they would capture that information and pass it to the Safety Commissioner's team, so that when the complainant first spoke to the Safety Commissioner's team, they would already have been briefed in on the issue. That was not something that the e-safety team wanted us to pursue due to the issues with handling sensitive information and the potential that somebody would approach somebody who wasn't appropriately trained in doing that. The other idea was using a working group that we have that involves a number of agencies, but when we looked into that further, that group doesn't look at policy issues of substance. It's very much a communications forum, so it wasn't the right place for that conversation.
Can I ask you then about recommendation 18, which is a recommendation about the adult cyber abuse scheme, which Ms Ricard suggested should be amended by lowering the threshold for content to come within the provisions of that scheme. The government response to that recommendation was noted, is that right?
Yes, that's right.
And Is it proposed from the work that your department is doing that the adult cyber abuse scheme will be amended and operate in tandem with the digital duty of care, or will it be replaced by the digital duty of care?
It hasn't been decided as to whether it will be amended in that way or not, but it will continue and operate in parallel to the duty of care.
I see. Thank you. Recommendation 20 is a recommendation that the Act should include some additional powers to require end users to stop posting cyber abuse about an Australian user in an end user notice subject to civil penalty, and again that is something the government response says is noted.
At the time when we prepared the response, we hadn't worked through that in detail with eSafety. We have since worked through that, and we understand there is a power under the child cyberbullying scheme for an end user notice to be issued, which requires the end user to delete content that exists and to refrain from posting further harmful content about the same person. Under the adult cyber abuse scheme, the end user notice can only require the end user to remove notice. It doesn't have that similar provision to refrain from further posting about the same individual. So that is something that we will look to build in through the amendments.
To bring the operation of the two provisions into alignment?
Yes. So
that is as between children and adults?
Yes, that's correct.
And then recommendation 21 is the recommendation about a definition of online hate material.
Yes.
And again, that's a recommendation that's simply noted by the government in response.
Yes, the Minister's office asked us to do further work on whether that would still be needed if the duty of care was effective.
And has the government come to has the department, excuse me, has the department come to a more considered view on that topic?
No, we haven't. We are still looking at a potential definition of online hate. It is, as you would be aware, a very complex area. So we haven't arrived at a position on that yet.
Is that an area in which you have sought legal advice respecting
a definition of
yes.
online hate? No, I don't think we have.
This recommendation of Ms Rickard's reflects a concern that has been expressed by many representatives of Jewish community groups over a number of years.
Yes.
And the concern being that there be an explicit acknowledgement in the scheme as it is legislated and applied that is capable readily of capturing references to anti-Semitic content, both in a context of child cyber abuse and adult cyber abuse.
Sorry, could you repeat the question? I'm sorry.
And are you aware that representatives of Jewish community groups have pressed for a definition of online hate material for reasons including that it is regarded as important that there be explicit identification of anti-Semitic harmful or hateful content within the regime, within the scheme?
I am aware. I have only recently become aware of that through recent work of this commission and the media reporting. I wasn't previously aware of the very strong views held in the community, so that is something that we can certainly do further work on.
Is it proposed that legal advice be sought to assist the department in its task of considering whether or not there should be a definition of online hate, and if so, what the content of the definition should be?
I am not aware of whether we have a specific proposal in hand to seek that legal advice, but it is something that we would certainly need to do throughout the drafting process.
Does your branch include legally qualified people?
No. There may be one or two officers who have legal degrees, but they're not practicing legal officers.
Can I take you to a document, DTR.0416.0001.0380. This is another document recording stakeholder meetings and their contents
Yes.
in the context of the review of the Online Safety Act.
Yes.
And you see the attendees here were a number of people.
Yes.
Including representatives of the Jewish community.
Yes.
Can we take down this document? I'm told it can't be displayed. Is there a... Pardon me for a moment,
Yes.
Commissioner. 0006. To the page 0006. Yes, I think that's right. Yeah. Sorry, Commissioner, I just...
Not at all.
That's different then.
Technical problems
Oh,
tend to get
that's in there.
amplified on a Friday. As I understand it, Ms. Vandenbroek, you might be the only person in the room with a copy of the actual document at the moment. Do you have a copy of this list of stakeholder, or a stakeholder meeting in February 2024?
No, I don't think so. Sorry, could you repeat the document number so
Yes.
I can see if it's on the end?
It ends with .0380.
380. Oh, maybe I do. Yes, I do have that document.
Commissioner, if I can just ask a question by reference to the witness's copy, and then we'll
Yes.
make other copies available subject to any
Yes, by all means.
confidentiality issues. You can see, Ms. Vandenbroek, that on 19th of February 2024 there was a meeting with the Executive Council of Australian Jury,
Yes.
and among the key points recorded from the meeting is that online hate is identified as a gap in the current regime,
Yes.
and in parentheses it's noted that it's not currently identified in the Online Safety Act.
Yes.
So at least since February 2024 the department's been informed of the concerns of representatives of the Jewish community that there isn't a identification or definition of online hate in the Act.
The department had been. I personally wasn't aware.
Yeah.
I hadn't commenced at the time of that meeting.
Thank you. Now, can I ask you about recommendation 43, which is a recommendation that requires major platforms to have a local presence in Australia, and I took you a little earlier to paragraphs 158 to 160 of your first statement, which is where your statement addresses this recommendation. And I've already asked you some questions about this, but can I just confirm whether further consideration has been given to this issue? I gather from your earlier answers that this recommendation, because the government's indicated it would not implement it, it is not being actively considered at the moment by the department. Is that right?
This is, so the licensing recommendation.
The recommendation 43,
43.
the requirement to have a local presence.
Sorry, yes. It's not something that we're doing further work on at the moment, no.
For the reason that you explained earlier, that the government had, or that the government had previously indicated it would not be pursued.
Yes.
And recommendation 49, can I ask you about that recommendation, which is a recommendation that the government consider options for introducing a licensing scheme for major services as a condition of operation. Has the department considered whether a licensing scheme would represent an effective means by which to make social media platforms subject to Australian regulation?
We have considered it at a very high level, but we haven't done any detailed work on it. It is a recommendation that we were informed from the Minister's office. It would be a very big change in the way that the regulatory framework is structured, and it's not something that they wanted us to pursue. The preference was to direct work towards the digital duty of care at this time. And
you I think indicated work had been done at a high level. What work had been done on?
To look at how complex it would be. Certainly if it was something that was simple to do, we would have recommended to government that it be pursued on a faster time frame, but it is clear that it would be a very complex piece of work to find a regulatory regime that would be fit for purpose, a licensing arrangement that would suit across the very diverse range of online services that are available. So to work towards an appropriate licensing agreement and to negotiate something with all of the relevant players in the industry would be an enormous piece of work. And we're just not resourced to be able to progress that at the same time as the duty of care and the social media minimum age and the classification reform, which are the three priority areas.
I take it from your earlier evidence that you're not aware of any advice sought or received by the government in respect of the proposed implementation of a licensing scheme of that character?
Not at this stage, no.
Do you mean that you're aware of a proposal that such advice be obtained?
There's nothing concrete, only that it's something that may be looked at later.
And is that a departmental decision, or is that something the Minister's office has informed you about?
That would be for the Minister's office to ask us to do that work.
Commissioner, I've almost completed my questions. Perhaps if I could have a minute or two.
Yes, by all means. I might just take up one matter with the witness while you take those couple of minutes. Can I just ask you about this in relation to the government's response to the Rickard review? In relation to recommendations 18, 20 and 21, it was noted that these required further considerations as they suggested a response to individual incidents and or users rather than the systemic approach of the duty of care. And then the response went on to say this: while lowering the threshold of the adult cyber abuse scheme would appear to provide greater support to Australians who experience online harm, it is likely that expanding the scheme would be operationally burdensome and counterproductive. Can you just expand on the basis for that view?
That was on the basis that lowering the threshold would be expected to increase the volume of complaints received by eSafety. that would then require them to have an uplift in resourcing
Yes.
in order to deal with that, and an effective triage process to make sure that the more serious complaints that are currently captured with the higher threshold weren't missed due to the expanded volume of complaints that we would expect they would receive.
Yes. Given the recognition that lowering the threshold would appear to provide greater support to Australians who are experiencing online harm, was consideration given to the desirability of expanding substantially the resources of the Office of the Commissioner of E-Safety?
It's not within the department's powers to give that consideration. That would be something the government would need to consider.
Just in terms of a recommendation, though, I'm wondering, on the one hand, one has acknowledgement that this recommendation made by Ms. Rickard might be beneficial for members of the Australian community who are experiencing the adverse effects of online hate, but the government's response noted the practical consequences of that. In terms of the department feeding in advice,
Yes.
was any consideration given to the fact that there would be a flow-on in resourcing terms, but that might be something that was worthy of support?
I don't remember the specifics of our advice, but we certainly would have, in advising the Minister about that recommendation, we would have made her aware that there would be a significant increase in resourcing, that it would help more Australians, but it would be a significant uplift. To the extent that I remember the conversations with the Minister's office, their preference was that we focus on the digital duty of care and how that might actually help with some of the recommendations, like where adult cyber abuse is amplified by volumetric attacks, and that is because of the features of social media services recommending, amplifying, duplicating, promoting that kind of content. And if the algorithms are designed with safety by design principles, whereby harmful content isn't recommended, isn't amplified, isn't duplicated, that instead would help to reduce the impact of adult cyber abuse.
And in the absence of any requirement that social media platforms have a presence in Australia,
Yes.
and in the absence of any scheme for registration, has consideration been given to the effectiveness of the proposed digital duty of care to protect Australians from online hate and the like?
I'm sorry, I'm not sure I understand the
yes,
question.
If one imposes the digital duty of care
Yes.
on a platform that has not shown itself particularly cooperative, if I can put it that way,
Yes.
and that platform doesn't have a physical presence in Australia and is not required to,
Yes.
and you don't have a licensing scheme or something of that nature,
Yes.
then in your assessment, will the digital duty of care operate to adequately protect Australians?
I think it will be a case of designing the digital duty of care to be as effective as it can be.
As it can be for a company that has no physical presence in Australia and is not required to be licensed in order to operate here.
That is obviously a challenge, yes.
Yes.
I'll only take a moment, Commissioner,
Yes.
to complete my questions. Ms Vandenbroek, yesterday the E-Safety Commissioner gave evidence, including about resourcing of her office,
Yes.
She indicated that counting the number of complaints submitted in 12 months period to the end of June 2025, it was 55,000. To the end of June this year, it was 108,000 complaints that her office had to deal with. In light of that explosion in the number of complaints to the E-Safety Commissioner's office, are you aware of any consideration within government to increase funding and staffing levels of the E-Safety Commissioner?
There's not currently a consideration. The Safety Commissioner's funding was increased in it might have been the 2023-24 budget, where the baseline funding was significantly increased to account for the increased workload there. We didn't put a proposal through the most recent budget for resourcing relating to the duty of care because we hadn't designed the duty of care yet, but there is an expectation that the Minister would seek authority to seek additional resourcing at a point in the future, but there's no concrete plans.
But even on the current legal and regulatory framework, the E-Safety Commissioner's work has pretty much doubled year to year 2025 to 2026 and has tripled 2024 to 2026. In those circumstances, there's not a very strong case for giving consideration to increase funding and staffing of the E-Safety Commissioner so that the legislative functions of that office can be discharged.
That's not something the E-Safety Commissioner has raised concerns with the department about funding for litigation and being able to adequately respond to legal cases on hand and to legal cases they would like to initiate. There hasn't been any resourcing in relation to complaints that I'm aware of raised with the department. Their concerns have been in relation to litigation funding.
I don't have any further questions. Thank you.
I was going to seek to ask about 5 minutes worth of questions, Commissioner.
Yes. Do you have any idea how long you're likely to be, Mr. Bender?
About 5 minutes, Commissioner.
Yes, we'll proceed.
I appear for the mainstream Jewish community bodies, and I have some questions about recommendation 5 for you. You addressed that in your statement at about paragraph 78. And you'll recall that recommendation 5 was a recommendation made by Ms. Rickard that certain harms should be highlighted for attention under the proposed duty of care, one of which harms was attacks based on a person or group of people's protected characteristics such as sex, gender, sexual orientation, race, ethnicity, disability, age or religion. And you've said at paragraph 78 that the drafting instructions for the duty of care incorporate all elements of recommendation 5 except the reference to attacks based on a group of people's protected characteristics. You aware of that?
Yes.
You've also said at paragraph 80 that the scope of the duty of care won't extend to cover harm in the form of attacks based on a group of people's protected characteristics. Now, what's referred to as a group of people's protected characteristics in a general sense is a minorities group's characteristics that might be the subject of an online attack. That's how you understand it, isn't it?
Yes.
And you're aware that in the course of Ms. Rickard's report, she referred to very high volumes of online abuse that were being experienced on that basis.
Yes.
Is it proposed that the duty of care be drafted with any express protection for a group of people's protected characteristics or a minority group at all?
Not at this stage. It is something that we can look further at I can expand on the reasons for that. To date, the work that we've done has been to look at how we would maintain the way the Act is currently framed. The government has been clear that we will only regulate what people can see in Australia or what Australians can view online. It is not the remit of the Online Safety Act to regulate what people in other countries can or can't see. And at the moment, if we were to regulate a tax on a group of people, that could then capture content generated in another country, targeted at people in another country. But we very much respect that people in Australia might find that content to be very harmful. But we would need to find a way to regulate so that we are only stopping that content being seen by people in Australia. We're not regulating what people in other countries can and can't see.
Am I correct in understanding that the present intention is to legislate a duty of care that would not have an impact on the ability of platforms operating offshore to publish material into Australia?
Sorry, can you repeat that question?
Am I correct in understanding from your last answer that the intention when drafting the legislation is that the duty of care will not operate to the extent that it prevents that it requires the platforms to prohibit speech coming into Australia from overseas?
No, sorry, I haven't been clear. At the moment, the Adult Cyber Abuse Scheme acts for the Commissioner to be able to take down information that targets a particular Australian adult, and equally with the Child Cyberbullying Scheme, it's about an identified Australian child. What we need to look at with a tax on a group of people is whether it can be a tax on a group of Australian people. So for content to be taken down under the Adult Cyber Abuse Scheme, the Commissioner needs to be able to prove that there was an intent to seriously harm an Australian adult. Proving intent to seriously harm a group of Australian adults or a group of Australians of a particular characteristic would be very difficult when a lot of the hate speech online is unfortunately very generic, and it would be difficult to prove that intent to harm a group of Australians.
So does that mean that online hate speech directed at Jewish people generally, as opposed to Australian Jewish people, wouldn't be within the remit of the duty of care?
Not as it's currently scoped. It's something that we need to look further at as to how we could affect that without, as I said, significantly changing the scope of the Online Safety Act to seek to regulate content that people can and can't see in other countries.
Because one would expect a very small proportion of the anti-Semitic content online to be directed only at Australian Jews as opposed to Jews. That's right, isn't it?
That's correct, yes.
Are you aware of whether that hole in the legislation is something the government will give further consideration to in the future?
I'm not aware of whether they plan to consider that or not. It's certainly something that we could provide further advice on.
How, as you understand it, is it proposed that the duty of care will promote a safe online environment for Australian Jewish people in circumstances where most of the anti-Semitic content online doesn't originate in Australia?
Through regulating the features of services and requiring safety by design principles and requiring that platforms actively prevent, to the extent that they can, harmful content, and that they detect and remove or mitigate harmful content when they are aware of it, and also through having safety by design principles applied to features like algorithms so that harmful content isn't recommended or duplicated or promoted.
But as I understand the position, nothing in the legislation is proposed to ensure that harmful content is defined in a way that specifies harm to a minority group. Isn't that a problem?
I would need to look again at the detail. I think you're correct that it's not currently proposed in the framing of the harms.
Are you aware of the large volume of abuse, anti-Semitic abuse directed at Deborah Conway last year that was reported to the E-Safety Commissioner?
No, I'm not, sorry.
Thank you, Commissioner.
Thank you. Mr. Chaplain.
No, I have no questions, Commissioner.
Just one thing, taking up the matters that Mr. Bender raised with you, you said that the department could take on consideration of issues relating to hate speech directed to a minority group in relation to the proposed digital duty of care, but as I understand you, the instructions for that digital duty of care are presently with Parliamentary Council.
The first tranche of instructions are there, that there are placeholders within those instructions for further detail to be provided.
Yes, thank you. Anything arising?
No, thank you, Commissioner.
Thank you, Ms. Vandenbroek. You're excused.
Thank you.
I'll now adjourn for 15 minutes.
this.
Yes. Sir, will you take an oath or make an affirmation?
I'll take an oath.
Thank you.
Do you swear by Almighty God that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you.
Please state your full name.
Theo Hourmouzis.
You are the General Manager of Anthropic ANZ.
That's correct.
You have prepared a statement dated the 25th of June 2026.
I did, yes.
Are the contents of that statement true and correct?
Still true and correct.
Commissioner, the statement bears the ID STAT.899.001.0238, and I tender Mr. Hourmouzis' statement.
Yes. Yes, the statement will be marked as an exhibit, and I might just note, Mr. Lancaster, that the appearance of Mr. Roche of Senior Counsel with Mr. Mitchell for Anthropic.
Yes, thank you, Commissioner. I'm sorry for launching straight into it. Mr. Hourmouzis, you're employed by Anthropic Australia Proprietary Limited.
That's correct.
That company is a subsidiary of Anthropic Public Benefit Corporation.
That's true, yeah.
And you're the General Manager of Anthropic in Australia and New Zealand.
Correct.
You started in that role in May 2026.
I did.
And your statement indicates you've informed yourself of Anthropic's policies and processes by reviewing relevant documents and information given to you by other Anthropic personnel employed by Anthropic PBC.
I have, yeah.
That is the parent company located where?
Located in the United States.
And
San Francisco.
in San Francisco.
Yeah.
You note in your statement that all relevant information was provided to you by Anthropic PBC and no information was withheld on the basis that it was retained by an affiliated entity.
That's correct.
In terms of your own background, do you have technical qualifications?
My background has been focused primarily on go-to-market strategies, so more on the sales execution side of organisation.
Yeah. And so what previous roles have you held?
Similar roles for other technical companies based out of San Francisco or the United States as well.
And you came to Australia to take up this position?
I live in Australia. I was born in Australia, so yeah.
Do you have formal education qualifications in engineering or other technical areas?
Not in technical areas, no.
Is your training in business affairs and marketing?
Correct, yeah. More
So-
on the business affairs side. Yeah.
So just if you could identify what are your qualifications in that respect?
So tertiary education, Diploma of Information Technology is the level that we got to.
You identify in your statement that you're Anthropic's most senior commercial officer in relation to major enterprises and regulators, is that right?
That's correct, yeah.
Anthropic began a presence in Sydney, in Australia, for the first time on 27 April this year,
That's correct.
and it has 15 employees in the Sydney office.
Yeah, that's accurate.
Now, could you explain what Anthropic Australia does, if anything, in relation to Anthropic's large language model and development of that model?
Yeah, the technology itself is not developed here locally. The workforce here is primarily around finance, policy, sales, execution. There are no Anthropic capabilities of local inference, so serving the models on Anthropic infrastructure in the country. So it's clearly around interfacing with our customers and helping them take the advantage of the models themselves.
The provision of services by Anthropic to Australian users, to the extent it occurs, and I'll get to that in a moment, but it's It's performed by other members of the Anthropic group of companies
That's correct.
who are not domiciled in Australia.
That's true.
Nevertheless, Anthropic Australia has complied with the Commission's notice by making inquiries of the broader corporate group,
We have, yeah.
and evidence is that those entities have provided documents to Anthropic Australia, which have then been on-provided to the Royal Commission.
Correct.
Commissioner, I note that there is quite a large documentary production. I haven't tendered that for present purposes because there are some questions of confidentiality to be resolved as between the legal representatives.
Yes, thank you, Mr. Lancaster.
Mr. Hourmouzis, can I ask you about Claude? So Anthropic is focused on developing large language models,
Yes, that's correct.
and could you explain what they are?
So a large language model is essentially a program that is trained on a wide variety and enormous amount of text, with the idea of learning the pattern of language to be able to predict words that are typically following from certain other words. So essentially, if you train these enough, that pattern matching turns to some level of understanding. So the easiest way to explain this is it's software that learns a language the way that people do. It allows us to interface with that language as if it's a colleague that's sitting beside us.
And Anthropic's key commercial large language model is called Claude.
It is called Claude.
And is it right that most of Anthropic's revenue comes from businesses that pay a fee to access Claude via an application programming interface?
That's correct. Most of our customer base revenue is based on enterprise customers themselves. Whilst we do have consumer capability, the majority is from the enterprise.
Yeah. So individuals are able to access Claude through a web interface and through mobile and desktop apps?
That's correct, and the API, as aforementioned.
And how many approximate users does Claude have in Australia?
There's approximate 2 million consumer users here in Australia. The number is somewhat larger when you start to consider those that are interfacing with the API as well.
Can you briefly describe the various uses of Claude and what it's not used for?
The primary use for Claude is things like text summarization of documents. It's agentic workloads to help organisations optimise workflows, content creation as well to some extent. They're the primary use cases.
And is it right that Claude does not have a video or image generation capability?
It does not have a native capability in the platform, no.
And when you answer the question that way, is it able to be used with other software?
Yeah, so Claude itself has built a large ecosystem of other organisations that connect to the platform. Most of those are focused around enterprise software providers that connect to the platform, and so by design, it can connect to other tools and resources to deliver certain outcomes.
And for an individual user who accesses Claude in Australia, is such a user able to generate video and image?
Not natively to the platform, no.
Yeah. In its ordinary appearance, in its ordinary state that is accessed by Australian users, are there non-native associated programs by which a user of Claude can generate video or still images?
There are potentially some capabilities that allow for that, Council. The names of those don't come to mind very clearly. Our focus has primarily been on enterprise.
Where there might be that capability, would that need to be something that an individual user separately acquires or gains access to, or is it provided as part of a package with Claude?
It's not provided as a part of the package to Claude. All plugins require third-party capabilities and licensing for them to do that. So they're not native to the platform, no.
In your statement, you emphasise the difference between Claude and social media platforms. Could you briefly describe for the Commissioner the difference?
Yeah. So it is important not to categorise Claude as a social media tool. It is a business tool first and foremost, and the primary difference with that is the interaction with Claude is on a one-to-one basis. So it's user-initiated, and it doesn't serve content through any algorithmic forms. It only responds to the prompt that it's been given by the user.
And is it right that Claude does not use algorithms that automatically show users additional content?
That's correct. It doesn't have that capability.
And is Claude supported by advertising?
It is not supported by advertising. Our revenue comes from paid subscription and enterprise organisations.
And for an individual user, would that be by way of paid subscription, would it?
Correct, yeah.
Now, can I ask you about the steps that Anthropic has taken to implement safety measures in terms of the safety to a user of Claude and to the potential subsequent use of material generated with Claude's assistance? You've referred in your statement to pre-deployment safety testing before Claude is made available to the public, and in that regard you identify the responsible scaling policy of Anthropic.
Yeah.
Could you explain what that is, please?
So the distinction with Claude and large language models from Anthropic, there's a series of steps that happen before the model is released to the public, and that is all around safety. So first and foremost, it's the way the model is trained. There's a concept of what's called a constitutional AI capability, which is a series of policies to train the way the model should respond, with the outcome of the harmful content never being created in the first place, so it doesn't need to be moderated in post hoc environments. The responsible scaling policy is one of the series of policies within that training framework that determines the threat level of the model itself, and then that enacts certain ways of us applying different safeguards to the model. Most of the responsible scaling policy is geared towards things like bio, chemical, explosives, more focused on the critical kind of elements of AI.
And does Anthropic conduct pre-deployment safety testing to gauge Claude's willingness to generate hate speech?
Yeah, so through the process, the constitutional AI policies are engaged with the model to test it through many other policies as well. So there's extreme violent extremism policies, there's hate and discrimination policies, all of these applied through the training model. Once the model has been trained, then there's another series of tests that are applied against the usage policy that every single user accepts to determine how the usage policy could or could not be breached. And so there's just a multi-layered approach to safety and testing, all with the idea of harmful content should not be created in the first place.
Your statement refers to something called the model system cards. Could you explain what they are?
The philosophy of Anthropic's journey and beginning was centred around safety in the beginning and being transparent about how the models respond and react to certain things. The safety cards are the transparent output of the model training itself, and we share that publicly with the world so they can understand how we train the models and the outputs of those themselves.
Your statement identifies that before the public release of the Claude model, and by the way, that's an iterative process, is it? There are generations of Claude, if that's the right description, that are released.
Correct. There are many versions of models that iterate over time. and each one of those go through the same process of testing. The policies and the safeguards that are applied are always adjusted with each model as well as some of the third-party testing allows us to modify and improve those testing safeguards also. So it's an iterative process.
And in terms of hateful or discriminatory speech, specifically including anti-Semitism, there is a system card that is applied to determine the Claude safety if sought to be deployed for that reason?
So through the training process, we take a policy-based or a framework-based approach. We don't isolate certain religions, race, or ethnicities. We keep that in a broad policy framework that anti-Semitism would fall within those frameworks as well.
Right, well, you've referred to, this is in paragraphs 41 and 42 of your statement, to the Opus 4.8 model of Claude that involved multi-turn evaluations, which, according to your statement,
that's correct.
Nearly 200 of these related expressly to anti-Semitism. So could you explain
That's correct.
that process?
Yeah, so whilst we take a policy framework approach to this, during the evaluation process, the safeguards team have a series of prompts that they would present towards the model. They're very specific responses that are trying to determine whether the usage policy is enforced or not. That's the part of the process that you're reading there in paragraph 41. And in this instance, with Opus 4.8, there were nearly 200 of those multi-step conversations that happened. And so this is a series of prompting the model and then continuing to prompt the model to see how it responds on long-term conversations. And as you can see there as well, the success rate of not returning any harmful content was 100%.
So is this right that is meant to provide a pre-release analogy to a real-world potential for somebody to subscribe to Claude, to sit down in front of it, to put in multiple prompts to the AI attempting to generate anti-Semitic content?
Correct.
And then what is Claude's response?
So in the instance of anti-Semitic content was asked to be generated, there's a series of responses. In its first response is a redirect, trying to educate the user on going down a different path of topic. If they are persistent in that multi-turn step, it'll then just end the chat altogether. And in cases of extreme violence that are near and imminent, it can go all the way through to law enforcement as well.
In other words, automatically contact law enforcement, is that what you?
It'll inform our enforcement team, our policy enforcement team, who will then bring in the appropriate law enforcement.
And is that function presently operational in respect of users in Australia?
That's correct. Yeah.
And
can I take it that if a subscriber to Claude asks it what's the most effective means to suicide, Claude will not respond with the answer to that?
With that particular incident, Councillor, I'm not close to the details of that, but in general terms, it should not respond to those.
Thank you.
Your statement refers to the pre-release testing, and you've just referred to it in your answer to my question, where you indicated that the pre-release testing prevented 100% of conversations involving hate and discrimination, including anti-Semitism, progressing to a final product. Nevertheless, do you accept that there are cases in which a user might be able to use Claude to generate anti-Semitic content?
Yeah, whilst the testing showed it was a 100% success rate, there are instances where that might be possible, and there's an example within my statement here where once we received the notice from this commission, we did a test of over 50,000 chats within the platform, and there was an extraordinarily low return rate of those of 0.01%. So 5 instances that Claude had identified were anti-Semitic of nature that we caught and responded to those.
Now, one of the matters that you address in your statement, when you're talking about the application of the principles of, I think it's described as the core values in the Constitution that you referred to. You say that the Claude model exercises contextual judgment. Now, do I take that to mean that Claude has a level of sophistication that is readily able to identify the use of particular words, phrases, emojis in their context?
That's correct.
And how was the, I withdraw that, in developing the testing framework for Claude and indeed for improving Claude's behaviour, your statement indicates that Anthropic has worked with the Anti-Defamation League in the US.
That's correct.
Could you explain to the Commissioner the nature of that engagement and why it occurred?
So the Anti-Defamation League, ADL, is an external agency, a non-government organisation that is focused on anti-Semitic topics themselves. They tested a series of 6 other frontier model labs, similar to Claude Anthropic from Anthropic. Their series of tests were to determine whether the models themselves could produce content around anti-Semitic discrimination. Claude themselves, the product itself, ranked number 1 on that list with the highest score of all of the frontier models through those testing.
I'll come back to that in a moment, but just more generally, assume there is a bad actor individual, if I can refer to it that way, who does wish to generate anti-Semitic content and distribute it. As you've explained, Claude is not a social media platform. It does not itself involve posting content to other users.
That's correct, it doesn't do that.
And so a user of Claude with bad intentions in respect of the spread of anti-Semitism would be trying to develop content that could then be used in other programs or in other contexts in order to spread it. Is that right?
That would be the only mechanism.
Yeah.
That's correct.
And so the bad actor that I've asked you to assume would be trying to generate, for example, a whole range of different anti-Semitic content or comments that might then be used in other contexts to post or spread that content.
That would be the only way that could happen, yes.
Now, you referred to the extraordinarily low number of 5 out of 50,000 examples that were examined as permitting the generation of anti-Semitic content. Is that right?
That's correct, yes. In the 14-day period, June this year, that was stated in the statement, yes.
And so that 14-day period, that was the number of 50,000 was all of the generated content for that period?
I'm not sure I understand the question, the council.
That was just a sample. A sample of.
It was a sample
50,000.
size. It was not all correct.
So, how many instances of the use of Claude would occur over that period? There'd be millions, hundreds of
Millions. Yeah, I don't have the exact number, but it'll be exponentially more than the 50,000.
Yeah. And the 50,000 was a random sample of 50,000, or did they already have identified characteristics?
A random sample is my understanding.
In absolute terms, 5 out of a random sample of 50,000 in that context is nevertheless a material absolute number. Do you agree?
Are you asking for my opinion if that's a material absolute number? I would say 0.01%. Whilst it's not perfect, I wouldn't say it's an absolute material number. I think there's always room for improvement, though, Council, and that's the work that we spend a lot of time on ensuring the policies are reviewed to get as close to zero as possible we can.
Now, just pardon me for a moment, please. You've provided in your statement at paragraph 123 and following some evidence about Anthropic's ability to become aware of and review prompts entered by Australian end users in Claude by way of an attempt to generate anti-Semitic or other extremist content, haven't you?
In 123, yes?
Yes. And you've indicated that Claude has a automatic retention of conversation logs for some 30 days.
30 days, yes.
And has that period been developed in consultation with regulators or law enforcement agencies or the like, or don't you know?
I don't have an accurate answer to that, Council. I'm not close to the policy around building the 30-day retention.
You've indicated that even though these conversation logs are retained and they're able to be reviewed based on the location of the end user, that there are difficulties in the detection of specific topics within a single conversation. Can you explain that difficulty and the way that might be able to be addressed?
So my understanding is there's a privacy tool that allows us to collect certain groups of conversations into buckets, not necessarily individual, and those are then therefore flagged with the safeguards team, and only a select few people within the organisations and the safeguard team have the visibility to be able to go into those and have a look at more context. That level of visibility doesn't reside here in Australia.
It does not reside here, did you say?
It does not reside here in Australia.
Do you mean that the review team overseas does
They're all
not review
overseas.
Australian end user conversations?
Yeah, so the review team themselves, the safeguard teams, reside overseas.
Yeah.
Correct.
Yes, I see. Now, you've explained in your statement that users who are identified as expressing anti-Semitic or discriminatory or hateful views to Claude, there might be circumstances in which they are, to use the term you use, off-boarded. Can you explain the circumstances in which that might occur to a Claude user?
So there is a strike-based system where the model itself, the safeguards, try to redirect the conversation, and if it cannot redirect the conversation, the model itself will end the chat. In circumstances where there is extreme violence tendencies in the conversation, they are typically the ones where the user themselves are off-boarded. And in severe instances, law enforcement will be engaged if there's a clear and imminent threat to that as well.
We heard some evidence yesterday that Meta apply in one context 19 strikes and you're out policy. How many strikes do you get with Anthropic?
I don't have the details of that policy in front of me. My understanding is it's a much lower number than that.
You've estimated in your statement that the presence of anti-Semitic content generated by Claude is extremely low, is that right?
That's correct.
And you also accept, though, that Anthropic does not or has not systematically tracked trends in reports of anti-Semitism over time?
We have not. And I think the basis of that is the framework approach that we take. We don't have a specific anti-Semitic policy. It's captured under the hate and discrimination policy. But there is an enormous amount of testing voluntarily that we do with third-party groups to ensure that we reduce the capability of anti-Semitic content as well.
Just to understand what you mean by that, the testing for hateful speech generally is accompanied by specific attention to anti-Semitism among other types of speech. Is that what you mean?
So whilst our policies take a broad framework approach across things like race, ethnicity, religion, we have engaged third-party organisations with specific views on anti-Semitic content to test the models and help us advance our safeguards as well, voluntarily.
And have any of those involved in the testing been Australian-based organisations, to your knowledge?
Not today, Council. We take a global approach to this.
Is there any proposal you're aware of to incorporate that sort of engagement with Australian end users or representative organisations, given there are some 2 million individuals using it here?
Not to my knowledge.
Pardon me for that. Thanks, Mr. Hourmouzis. You've given some evidence in your statement that Anthropic employs, obviously enough, AI-powered techniques for detecting harmful content, but at the point of generation rather than the point of distribution. Is it right that Anthropic's own experience is that its automated classifiers of content are effective in detecting anti-Semitic content, including speech and coded speech and emojis and so on?
Yeah, that's correct, but there's always room for improvement on those classifiers as well.
Yeah. And Claude, from the description in your statement, analyses those words or replacement words or emojis in their context, in the text in which they're entered into the system.
That's correct.
And as you understand it, traditional or the existing social media companies like X and Facebook increasingly use AI for content moderation purposes.
I'm not sure how they do their content moderation.
I see. In terms of the identification of anti-Semitic words, replacement words and emojis by Claude, is that process of identification something that Anthropic regards as technically very straightforward?
Technically very straightforward. I'm not sure of the context of how you're explaining that, but it is a core part of the model itself and how we deploy that model to our users, and it's an important part of the delivery of that service as well.
In terms of the way an AI model can immediately assess the entry into a electronic system of anti-Semitic words or replacement words is a process that is very well understood by Anthropic.
That's correct, yes.
And as you would expect, very well understood by social media platforms.
You'd expect so.
And as a matter of the technical feasibility of preventing the entry of anti-Semitic words, anti-Semitic replacement words, emojis and images, in your view, it would be a very straightforward technical process to be able to identify when that is occurring.
In our view and in the way that we do it, yeah, that's accurate.
Commissioner, I don't have any further questions. Thank you, Mr. Hourmouzis.
Yes.
Thank you.
Yes.
Thank you.
Mr. Roche.
Thank you. Mr. Hourmouzis.
One moment, sir. I think your counsel has some
Okay.
questions.
Thank you. Mr. Lancaster asked you about the evidence you've given at paragraph 34 of your statement, Mr. Hourmouzis.
Paragraph 34.
And this was about the study, the sample study that Anthropic undertook in responding to the Commission to gauge the extent of anti-Semitic content on Claude. And you've said in your statement that in a sample of 50,000 exchanges over the last 14 days, that study found anti-Semitic content only appeared in 5 exchanges. Mr. Lancaster asked you about those 5 exchanges. Is it correct that all of those 5 exchanges were user initiated?
All responses, and including those 5 examples, are user initiated, yes.
And is it the case that in all but one of those 5, Claude pushed back or rejected the request?
That's correct.
I also wanted to ask you a question. The Commissioner asked you how Claude would respond if asked by a user what's the most effective way to suicide. While you were giving evidence, my junior put that request into Claude and it generated the response, "I'm not going to provide that information, but I want to check in with you. If you're having thoughts of suicide, please know that you don't have to go through this alone right now," and then provides a series of resources for the user and asks them, in the case of an emergency, to contact their emergency services, and also offers to discuss with the user what it is that's troubling them. Is that response consistent with the sort of response you expect Claude would generate in response to such a request?
That's accurate. That's consistent with the expectation, but I wanted to be sure before we answered that question. So thank you.
Thank you, Commissioner.
Yes, thank you, Mr. Roche. Anything arising,
Nothing
Mr.
arising, thank you.
Lancaster? Thank you, Mr.
Thank you.
Hourmouzis. And might I extend the Commission's thanks to Anthropic Australia's parent company for its cooperation with the work of this Commission.
Appreciate it. Thank you.
Yes, you are excused. Now I think, Mr. Lancaster, that is the last Mr. Hourmouzis is the last witness for today.
That's right.
So we're going to adopt that practice that I recall from the glory days before ATMs and internet banking, and we will have the Friday afternoon off.
And Commissioner, we're also scheduled to start at 9 a.m. on Monday.
We are indeed, yes. Nothing's for free, Mr. Lancaster, so it'll be a 9 a.m. start on Monday morning. I'll adjourn now.